Okay, my dear friends, as discussed with you earlier as well, that when we talk about the Indian Contract Act, so Indian Contract Act talks about the enforceability of a promise wherein a particular situation or particular promise is being entered into by the parties. So that particular promise should exist in the form of contract must satisfy the requirements of agreement plus enforceability by law, right? So we have started, we have discussed all these aspects. Until now we have discussed that formation of the contract should be between two or more parties. There should be offer and acceptance. There should be lawful consideration. Parties should be capable of entering into the contract. Along with that, there should be consent of the parties should be free. Now, when we talk about a contract, so we say it is a general law wherein the enforceability and non enforceability of a particular promise is being discussed. What are the terms of the contract? What are going to be the, we can say, the consideration in the particular contract? How, when, where, by whom, everything is decided by the parties, right? So whenever they are entering into the contract, they are the decision maker or decided by the parties. So we have discussed that offer can be subject to certain terms and conditions, etc., and the offer should be accepted by the acceptor as it is. We have discussed about the consideration. We have discussed about that the person should enter into the contract freely. There should not be any pressure or any compulsion in terms of which makes the consent unfree. There should not be any kind of mistake. So all these things make us understand that there is requirement, there are the things are decided by the parties. But when we say the enforceability by law, so there is a term which says that the particular contract should be the subject matter which is being decided by the party. That subject matter which becomes the object of the contract should be legal. So, legality of object and consideration is another important essential which should be present in a contract for its enforceability by law. So, now when we talk about the object, we are talking about the subject matter. So, when we say when a person is willing to do or not to do something, and the other person gives his assent to such an act or abstinence, there becomes a promise. So this subject matter कि वो क्या है, what is the particular subject matter, how it is going to be performed, when, where, by whom. So what is going to be performed, this what is the subject matter or the object of the contract. And when we talk about the consideration, so consideration means that when a party does something and the other party promises to do something in return, such an act or abstinence in return of the promise is the consideration. Now, in this particular situation, we cannot say that when we talk about legality of object and consideration, so it is interchangeable or it is one of the same thing. Object is the subject matter, as explained by Satpreet as well, and it's a consideration when Utkarsh told that when we are going to do that, this is something in return, the promise is consideration, but the object is the subject matter जिस चीज के लिए हम कॉन्ट्रैक्ट में कर रहे हैं, एंटर हो रहे हैं, जिस चीज के लिए हम प्रॉमिस कर रहे हैं. तो ये जर्नल लॉ आपका सब्जेक्ट मैटर डिफाइन नहीं करता, बट जैसे स्पेशल लॉज आएंगे, इफ यू टॉक अबाउट द गारंटी, तो उसमें आपका गारंटी सब्जेक्ट मैटर हो जाएगा. If we'll talk about the sale of goods act, तो उसमें sale of goods subject matter हो जाएगा. तो special act में आपका subject matter to a greater extent define होता है. But in case of Indian Contract Act, subject matter is decided by the party. So legality of object becomes one of the important essential for the enforceability of the Indian Contract Act and for the enforceability of the other rules. So, when we talk about this particular chapter, legality of object and consideration, so we have to cover section 23, 24, and I think 57 and 58. But this particular four sections talks about the whole chapter. So, yeah, 57 and 58 only. So, but this particular section 23 is the elaborated section which talks about all the activities which are considered as illegal or unlawful within the meaning of law. So when we talk about requirement, so section 23 says कि कोई भी आपकी जो एक्ट है या कोई भी आपका सब्जेक्ट मैटर है वो आपका फॉलोइंग डोमेन से अफेक्ट नहीं होना चाहिए या फॉलोइंग डोमेन्स के अंदर फॉल नहीं होना चाहिए. So this subject matter should be considered as the lawful. So lawful कब होगा जब वो इस कैटेगरी के अंदर फॉल नहीं करेगा. So consideration or object of the agreement is considered unlawful इन द फॉलोइंग केसेस. जैसे हमने डिस्कस किया था कैपेसिटी ऑफ पार्टीज में, सो हमने डिस्कस किया था कि इन कैपेसिटी ऑफ पार्टीज कहाँ होगी जहां पे वो माइनर हो जाएगा, पर्सन ऑफ अनसाउंड माइंड हो जाएगा और पर्सन डिस्क्वालिफाइड बाय लॉ हो जाएगा. सो इन दिस पर्टिकुलर केस इन द फॉलोइंग सर्कमस्टांसेस the particular object or consideration is regarded as unlawful if it is forbidden by law. फॉरबिडन बाय लॉ मीन्स कि या तो वो चीज आपकी रिस्ट्रिक्ट हुई हुई है, दैट इट इज रिस्ट्रिक्टेड, और इट इज प्रोहिबिटेड बाय लॉ. मीन्स कि आप उस पर्टिकुलर चीज के अंदर अगर एंटर करते हो तो उस केस में लॉ इज गोइंग अगेंस्ट और दिस इज कंसिडर्ड एज अनलॉफुल, इट इज नॉट एक्सेप्टेबल बाय लॉ. तो अगर हम कोई भी ऑब्जेक्ट या सब्जेक्ट मैटर है जो आपका परमिजिबल नहीं है उससे रिलेटेड अगर हम कॉन्ट्रैक्ट करेंगे तो उस केस के अंदर कॉन्ट्रैक्ट एक्ट के जो रूल्स हैं, जो रेमेडीज हैं वो अवेलेबल नहीं होंगी. और रेमेडीज क्या कहती है हमें कि अगर एक पर्सन कॉन्ट्रैक्ट कर रहा है तो उस केस में देयर इज लीगल ऑब्लिगेशन, और लीगल ऑब्लिगेशन है तो अगर वो परफॉर्म नहीं करता the other person has the right to go to court of law to get it performed or to get compensation for the non performance. तो अगर उसका ऑब्जेक्ट ही अनलॉफुल होगा तो क्या हम उसको एनफोर्स कर सकते हैं? यस, नो. यू कैन इवन राइट इन द चैट बॉक्स कि अगर कोई कॉन्ट्रैक्ट है जिसका ऑब्जेक्ट अनलॉफुल है तो क्या हम उस पर्टिकुलर वो कॉन्ट्रैक्ट बनेगा या वो एनफोर्स होगा आपके हिसाब से? व्हाट डू यू अंडरस्टैंड?
नो मैम.
ओके, वेरी गुड.
नहीं
सो
होगा.
हाँ, नाउ वी हैव टू अंडरस्टैंड कि किस किस सर्कमस्टांसेस के अंदर वो आपका फॉरबिडन बाय लॉ है. फर्स्ट वी से दैट इफ इट इज पनिशेबल अंडर आईपीसी. If any of the activity which is punishable under Indian Penal Code, then in that case, that particular activity is restricted by law. That particular activity is not to be performed because it would defeat the provision of the law. एक तरफ से तो हम कह रहे हैं कि ये पर्टिकुलर एक्ट जो है वो आईपीसी के अंदर प्रोहिबिटेड है, पनिशेबल है, और दूसरी तरफ हम उस कॉन्ट्रैक्ट को एनफोर्स कर रहे हैं. So that is not possible. So if any activity which is forbidden by law or any of the we can say that the special acts, special exhalations which are being made by the competent authority, and that is making the particular acts restricting or prohibiting certain activities. So in that prohibition also will be covered that unlawful, that will not be enforceable by law. For example, when we talk about the special act, so this can be special circumstances or certain special business transaction or anything like that. So if we, for example, we say that there is a restriction that a person has entered into a contract and he is being allowed that you drop the prosecution, you do not file a case against me, I will compensate you for otherwise. So if he drops the case, he drops the prosecution, and then he demands the compensation and the other person does not provide the compensation, then he go to court of law कि मैंने तो केस ड्रॉप कर दिया था इसके अगेंस्ट, and now he was supposed to give me the compensation and he is not providing me the compensation. तो आप उस चीज को compel नहीं कर सकते. So if something is prohibited, something is restricted, so if you are entering into that particular activity, so in that case the particular object of the contract will become unlawful. It will not be enforceable by law. तो जो अगर हमारा object unlawful है, so simple सी situation है that the particular agreement is going to be declared void. It is not going to be enforceable by law. It is void ab initio. So वो किसी भी लीगल राइट्स को, लीगल ऑब्लिगेशन को राइज नहीं देता, वो एनफोर्सेबल बाय लॉ नहीं होगा. तो अगर कोई भी एक्टिविटी जो आपकी पनिशेबल है इंडियन पिनल कोड के अंदर या फिर किसी स्पेशल एक्ट के उसके अंदर prohibited है, and if you are entering into that kind of activity, then in that particular case the law is not going to support you, the law is not going to help you to enforce the particular promise. Otherwise हम क्या कहते हैं कि कॉन्ट्रैक्ट के अंदर अगर एक प्रॉमिस एग्जिस्ट करता है, उसके अंदर ऑफर एक्सेप्टेंस है, कंसेंट भी फ्री है, कंसिडरेशन भी है, पार्टी केपेबल भी है एंटर करने के लिए, ऑफर एक्सेप्टेंस भी है, लेकिन अगर उस सिचुएशन में बाकी सारी सिचुएशंस अवेलेबल हैं बट ऑब्जेक्ट आपका अनलॉफुल है, लीगैलिटी ऑफ ऑब्जेक्ट नहीं है, तो वो एनफोर्सेबल बाय लॉ नहीं होगा. सो इन दैट केस दिस इज रिक्वायर्ड दैट दिस पर्टिकुलर ऑब्जेक्ट और कंसिडरेशन ऑफ द कॉन्ट्रैक्ट शुड नॉट बी अनलॉफुल. तो अगर वो अनलॉफुल होती है तो उस केस में हम कॉन्ट्रैक्ट को एनफोर्स नहीं कर सकते. For example, a student is seeking admission in a particular college and he has promised to pay 1 lakh to a person who is getting the admission sought. The person he has paid the 1 lakh rupees, but the person could not get him the admission in a particular college or a particular university where he has promised. Now you cannot go to court of law and can ask for this 1 lakh rupees back, that I have given this 1 lakh rupees for getting admission and he is not able to get me the admission. Yes, of course, if you have deposited some fee and that fee after that you get your admission cancelled, or you could not certain advance money is being given but you could not get the particular thing, then if it is in a legal preview you will get your money back, right? But if there is any activity which is forbidden by law, which is prohibited under any of the act, or which defeats the provision of the law, in that case, if that activity is being involved, then that particular promise cannot be enforced because the object, the subject matter of the particular contract is not lawful. Is this point clear to all of you? Yes?
Yes, ma'am.
Yes,
Okay.
ma'am.
Okay. Then in continuation, the next situation where the object or consideration shall be regarded as unlawful, that where the transaction or the object, if permitted, would defeat the provisions of law. It means that we have made the provisions of law to be abide by. So if we are allowing any kind of activity which is against or which is beyond the provisions of law, or if it is allowed that activity, so it means there is no point of having that provision. For example, we say that you are required to attend classes, you are required to submit your internal assessment, and you are required to give examination as per the university norm. And if you fulfill all the condition as per your course prescribed, then you are entitled for the degree of your course, right? So this is the these are the provisions made for the admission, right? And if off the line means not on records, but other than the records, one particular teacher exempts you from the point that no classes, no internal assessment, and no examination, right? And at the end of the transaction, you get no score for the paper. The teacher has not given any score or anything like that. So, can you claim it as a matter of right? The teacher has exempted us, and we have taken that exemption. So, we have not attended classes, we have not submitted the assessment, and we have not given the exam of that particular course. So, will you be eligible to get the marks in that? Can you file a case? Yes, no?
No, ma'am.
Because this is not a legal provision wherein that in because of this requirement, you agar in that case this provision would have not been required if the individual teacher is being permitted. But yes, if there is the notice, or there are rules or regulations from the university that for a particular batch the exams are not going to be held, or exams are cancelled because of the circumstances, or because of the offline exams cannot be conducted, and you will be promoted on a certain grounds or on the basis of the internal assessment, then this is valid, right? But if the provisions of law require certain things to be performed, and if we exempt these provisions, so it means any activity which defeats the object or the provision of law, such an activity is regarded as unlawful, right? A teacher has taken say some I should not ask use the word teacher, but if say anyone from outside has taken some money to provide you the question paper of a particular subject, and that person has not provided, or the question paper he has provided you to you does not match which comes in the final exam, so can you sue that person and can demand your money back? No, right? So in that case, any activity which is if permitted would defeat the provisions of the law, then in that case such an activity is not regarded as lawful, hence will not give rise to a valid contract, right? Let's move further. Another situation as per section 23. First, we have discussed if it is forbidden by law or prohibited by special act. Second, we have discussed any activity, if permitted, would defeat the provisions of the law. Then we have the third activity if it is fraudulent in nature. So, with respect to this, we have already discussed that if there is any activity which is fraudulent in nature, which has been made, promises made to deceive the other party, or where the party has the intent to making the promise with an intention of not performing it, or with an intention to compel the other person to enter into the contract willingly to take the undue advantage of the other. So, in that particular situation, such an agreement is going to be void. So, any agreement which has been entered into where the object or the subject matter of the contract is fraudulent in nature, then in our consideration is unlawful, then in that particular case, such an agreement is not enforceable by law. So, you have opened a company wherein you have invited the investment, and such activity is being done from the point of view to gabble the money of the other parties, or to cheat the general public. In that case, such contracts are not enforceable by law. So in that case, the other person voidable की option तो आपके पास हमेशा रहती है, that if there is a contract and the consent of the party is being affected by fraud, the person whose consent is so affected can set aside the contract. So contract is voidable in that particular case. But where the subject matter is fraudulent or is not with an intent to perform it, so हम क्या कहते हैं कि basic requirement क्या होती है contract की, that there should be an intention to create legal relationship. So if any of the party is entering into the contract from the point of view that with the not with an intent to perform the contract, then in that particular case the particular agreement is void, is not enforceable by law. Then there is if any activity, if it is of nature which is harmful, or we can say it's injurious to some person or his property. So in this particular case, if you are entering into a contract or making a promise with the other party, where the subject matter is that you are going to be, any activity which is harmful or which is in any case injurious to the person physically or otherwise, or to his property, in that case this particular activity is not going to be enforceable by law. For example, A gives 1 lakh to B to, say, set fire to house of C. Now, in this case, there is the harmful activity which is damaging the person or the property of the other person. So, in this case, B did the same. B was working at C's place. So, he did the same and then he claimed back 1 lakh rupees from A. He cannot do so. He cannot enforce this promise because it is void. It is not enforceable by law because the subject matter of the contract is regarded अनलॉफुल. सो सब जब आपका ऑब्जेक्ट अनलॉफुल होगा तो वो आपका एनफोर्सेबल बाय लॉ नहीं होगा. सो अप टिल नाउ फॉर इन एनी एक्टिविटी फॉरबिडन बाय लॉ, any activity if allowed would defeat the provisions of the law, the nature of the activity is fraudulent in nature, or the particular activity is harmful or giving damage to the person or property of another. The next situation, as per section 23, where the transactions are regarded unlawful, is that if the court regards the activity as immoral. Now, when we talk about moral values, immorality, so in this particular case, these activities are regarded as immoral, and it would depend upon the circumstances, the special laws in this particular situation. So in this case, this we can say the seen by the situation that why once the particular situation is immoral, or why when the particular situation is not immoral, so the court is going to decide the particular activity, that whether this covers being covered under the moral values or moral sentiments or not. So in this case, when we talk about these kind of activities, these kind of activities are considered as illegal. So it means that if the any party has entered into the contract where the object or consideration is regarded immoral, so this particular agreement is going to be void, is not going to be enforceable by law. For example, if we say that A has hired the car, and this particular car is being used for some illegal activity, or the purpose is to use the car to kidnap someone, and or it is to do any activity where it is not socially acceptable, so the particular transaction or the hiring of car will also be considered as illegal. So for example, A gives a money to B, that you have to obtain the divorce from your husband and marry the person subsequently. So this is regarded as immoral. This is considered as illegal. So this is not going to be enforceable by law. For example, A says to B, who has given some loan to C, that B is going to divorce her husband, and in lieu of that money, B is going to marry A in return after that. So in that case, there is this particular activity is immoral. This particular activity is not acceptable by law. Then in continuation, there comes that if the court regards the particular activity against the public policy, court regards the activity, regards it or activity, or we talk about the subject matter as opposed to public policy. Now, this point is going to discuss various aspects or various, changes in the law in the recent times as well. So, when we talk about the public policy, so how this particular public policy is being decided, or what are the activities? So, initially, the certain activities were not included in the IPC, but after 2012 protests, etc., there has been the amendment in the Criminal Law Act. So, Criminal Law Act talks about the any of the activity where certain activities are considered as heinous and considered as immoral. So they are not acceptable. So earlier there used to be the court discretion, and there used to be no definite imprisonment or punishment for the same. But after 2012 episode, there has been amendment, and even the minors were covered in case of the punishment bracket. Earlier the minors were not covered. Minors were covered under the juvenile code, and where certain relaxation etc was there. But now if there is any kind of activity which is in terms of we can say throwing acid or attempt to throw acid on anyone for causing the any kind of damage, this is considered as immoral, against public policy. If there is any kind of sexual harassment in terms of any form, then there is the punishment of 3 years or and fine, or both is being defined. If there is stalking any person without any intent or without any reasonable reason, following the females, and any kind of activities where there is a disinterest of female, there is also the punishment of 3 years is being decided. Similarly, in case of the rape, etc., there is the rigorous punishment for a term. For earlier it was for the 7 years, but now it is 10 years and 20 years. In case there is a it is committed by the minors, there is the 20 years minimum punishment, or which may extend to life imprisonment. If there is the below 10 16 years, there is a punishment of the 10 years or 20 years and extendable to life imprisonment. Then these activities have been included after that particular amendment in the Criminal Act 2013. Prior to that, the minors or these offenses were not covered in the Criminal Act. So now when we talk about the public policies, so these are considered as public policy. But there is a separate, we can say, the portion or the question with respect to the doctrine of public policy, and that particular point can come as a separate question as well, that what do we understand by the doctrine of public policy. So this is one where the court regards it against opposed to public policy. So according to section 23, these 6 points we have covered up till now. That is the first one we have covered, that is the subject matter, it is forbidden by law. Then we have covered where the object or transaction, if permitted, would defeat the provisions of the law. Then we have discussed that activity fraudulent in nature. Then we have discussed about the that if it is of nature which is harmful or injurious to the person or property of another, then if the court regards it as immoral, or the court regards it as the activity subject matter opposed to public policy. So now up till these points are covered, and now we have to cover the doctrine of public policy, which comes as a separate topic within section 23, or alag as a detail. Then after the doctrine of public policy, we will be discussing section 24, 57, and 58. So if you say, we can start the doctrine of public policy today itself, or in the next class, as per your understanding that how much you wish to learn more. Because it is going to take say 15-20 minutes topic is there. So if you say, we can continue in the next class, or I can continue it today itself. Yes, please.
Ma'am, next class.
Okay, fine. So up then we can take up the queries up till now, whatever points we have discussed. So let me stop sharing.